We're going to look at the Electronic Communications Privacy Act, or the ECPA. The ECPA is a federal law established in 1986 as an amendment to the Title III wiretap laws of 1968. It extends the wiretap laws to address electronic computer-based communication. It was amended by the Patriot Act in 2001 and 2006 to extend the ability of government and law enforcement to have access to electronically stored material. It's now very important in forensics and cybersecurity because it governs how law enforcement can get evidence from internet service providers, email providers, social network sites, etc. The ECPA is a complicated law, but this table summarizes it in a way that makes it easier to understand. And we will go through this table in more detail later on in the talk. But basically you can see that the ECPA breaks up the kind of information that law enforcement gets, shown here as the rows of the table. Basic subscriber information, other transactional information, etc. The columns of the table show, these two columns show what can be voluntarily disclosed by internet service providers, like can they voluntarily give email to law enforcement. And it's distinguished between public email service providers or internet service providers and non-public. These two columns show what law enforcement can compel or essentially order the internet service provider to give. And again, it's broken down to public provider and non-public provider. And we'll go through the definitions of these terms and then come back to this table and see exactly how the ECPA works. This page provides some definitions. Internet service providers are broken down to public and private. Public means that they provide service to the public, usually for a fee. Things like Cox, Comcast are typical internet service providers. Google is considered an internet service provider because it provides search services, email services, and Google Drive stored document services. Private internet service providers are things like businesses that provide internet service within the company for use by the employees. The ECPA also breaks down classes of evidence. Basic subscriber information is the first class of evidence. It's things like the name and address of the people communicating, the types of service they used, what kind of service do they use. The IP address that was granted to them is an example of basic subscriber information. What times did the sessions take place? So basically this talks about kind of the overall view of the communication, but not the content of the communication. There's a second class of evidence called other subscriber information. Again, not getting at the content because we see the content down here. Other subscriber information are things like transactional records, such as how much time was the account used, or what other people has a certain person been corresponding with by email. So if the evidence in question was a certain email, the to and the from of that email is considered basic subscriber information. But other people that one of the to or from subjects have been talking to is considered other subscriber information. The final class of evidence is the content of the communication. And we will see in the ECPA that it's protected much more stringently than the other two forms of information. The content of the information is like what's in the email. The ECPA also talks about different legal instruments that can be used for the compelling, which is the idea of law enforcement forcing the evidence to be turned over. A subpoena is the easiest legal instrument for law enforcement to get from the courts, but is also the less stringent. A subpoena basically directs the owner of the evidence to hand it over to law enforcement, but the owner collects it and gives it to law enforcement in the form that the owner decides is appropriate. On the bottom of the list of legal instruments is a warrant. And a warrant is where law enforcement comes in and actually takes the evidence, possibly with help of the internet service provider, but law enforcement is in charge of collecting the evidence, which is different from a subpoena where the actual owner of the evidence is in charge of collecting it. In between, there are two other legal instruments defined by the ECPA. A court order is basically a general description of something like it can be a subpoena with restrictions or a warrant with some loosening allowing the internet service provider do some of the searching and seizing. So a court order kind of falls between a subpoena and a warrant. And a subpoena with notice basically means that the people who are involved in the communication are notified that law enforcement has asked for their information. And under a normal subpoena, it's just the internet service provider giving that information. The communicating parties, the people sending and receiving the email, may not be told. But under certain circumstances directed by the ECPA, the communicating parties must be told that the subpoena has been issued. We saw that the ECPA differentiated between voluntary disclosure of evidence and compelled or involuntary disclosure. Voluntary disclosure is the idea that the ECPA regulates what an internet service provider can voluntarily give to law enforcement. In fact, it restricts it to help with protection of privacy of those using the internet service provider. We'll see in the table that basically voluntary disclosure of communications is disallowed by the ECPA. So the internet service provider is not allowed to give out your communications just to anybody. But there are some circumstances under which they can. For instance, if it's necessary to protect the internet service provider. So number one might be invoked in a hacking situation where the internet service provider is being hacked and the disclosure of information might be necessary to help law enforcement stop or respond to the hack. If the internet service provider can show that they inadvertently obtained the evidence, for instance, they were doing a normal maintenance routine on their servers and they came across child pornography or stolen credit card numbers, and it was shown it was part of their normal actions, they can voluntarily disclose the evidence or the contraband to law enforcement. If there's an emergency involving someone's safety, then they can voluntarily disclose. If there's anything involving violation of child protection acts, they can voluntarily disclose. So there are a number of exceptions, but in general the ECPA says that voluntary disclosure is not allowed by internet service providers. So we now take a look at the aspects of the ECPA as summarized in this table that we saw before. The rows of the table are different classes of evidence. Here is basic subscriber information, like the to and the from of an email. Here is the other transactional records from an internet service provider. This is like that the particular evidence was an email with to and from, but law enforcement might want to know who else the sender had been communicating with. That's other transactional records. Accessed communication is email that's been read or a document that's been opened and is stored on the internet service provider. Unretrieved communication that's greater than 180 days old. Unretrieved basically means unopened email or documents that haven't been opened. And the final class down here is documents that haven't been opened and are less than 180 days old. Now the different classes of information are listed here in the table in order of how difficult it is for law enforcement to get. So basic subscriber information is usually fairly easy for law enforcement to get, and we'll talk about what kind of instruments they need over here in this column. But basically, the basic subscriber information is very easy for them to get. Other transactional records are slightly harder for them to get. Accessed communications, like documents and opened email, are a little bit harder for them to get. Things that haven't been accessed, email that hasn't been opened, documents that haven't been opened, are much more difficult for law enforcement to get because they are treated as essentially still being on the wire. And the wiretap laws, which are very stringent, it's very hard for law enforcement to be able to get a warrant to do any kind of wiretap. Unread email is treated essentially as on the wire and falls under wiretap laws. Now the 180 days is broken up to make it a little easier for law enforcement to get unretrieved email that's old. But if it's relatively new, defined by the less than or equal to 180 days, the email is considered to be still on the wire and is very difficult for law enforcement to get. Let's now look at the columns. These two columns talk about voluntary disclosure of evidence from the internet service provider to law enforcement. That's like Cox giving information to law enforcement without them demanding it. These two columns talk about what it takes for law enforcement to compel an internet service provider to give evidence to them. So we can see that if it's a public provider like a Cox or a Google that's providing internet services to the public, it's basically disallowed for them to voluntarily give any information to law enforcement, except under the exceptions that we went through on the last slide. But if it's a non-public provider, like the internet service provided to the employees within a business, the business essentially owns that activity and can voluntarily disclose any of it to law enforcement. This column shows how law enforcement can compel an internet service provider to provide evidence. If it's basic subscriber information, law enforcement can get that with a relatively easy-to-get subpoena. In fact, in most states, something called an administrative subpoena can be used. An administrative subpoena doesn't involve law enforcement going to the courts. Law enforcement is given the power to issue subpoenas without going to a court. And it's only a certain form of kind of easier to get subpoenas that can be administrative subpoenas. But things like basic subscriber information from an ISP is often obtained by law enforcement without having to go to a court to get its subpoena. Other transactional records involve a court order. So the court order, the idea is that it would be a subpoena, but the court order would direct what forms of other transactional information. So it goes into a court order that's required to get other transactional information. Other access communications is essentially treated as a document, and you can see that law enforcement needs a subpoena, but also must give notice to the customer that the subpoena is in place. And the subpoena is typically harder to get than, say, a basic subscriber information subpoena. These subpoenas typically are not done with administrative subpoenas. Unretrieved communication that's greater than 180 days old falls essentially into the same category as if they had read the email. It's essentially a document with a little bit harder to get subpoena with notice in order to get it. But you can see here that unretrieved communication, less than 180 days old, requires a full search warrant. And the full search warrant tends to be very difficult to get because this is essentially considered to be a wiretap if it's unread communications still on the server. The final column here is what law enforcement can do to compel a non-public provider like a business. And it's essentially the same. The only difference really falls here in access communication, which is essentially a document owned by the business. If the document is owned by the business, the ECPA does not apply, and other rules involving subpoena documents from businesses come into play here. But otherwise, you can see that the ability for law enforcement to compel from non-public providers is essentially equivalent to compelling from a public provider. In addition to governing how evidence can be obtained by law enforcement, the ECPA also has a provision allowing law enforcement to direct internet service providers to maintain data for a longer period of time to allow them to be able to get together the necessary legal instruments to obtain the evidence. Typically, internet service providers keep certain information around only for defined periods of times, often usually a month or so, depending on the internet service provider and the kind of information. Law enforcement under the ECPA can direct internet service providers to preserve evidence longer. Typically, a preservation notice can be for 90 days, extendable to another 90 days. This allows law enforcement to get the necessary subpoenas, warrants, etc., and to get the necessary technology, tools, and personnel that would be required to obtain the evidence. The ECPA also has a provision that allows for law enforcement to direct the internet service provider not to tell the parties that are being investigated that they are being investigated. You'll note that back in the table we saw that certain forms of evidence do require notice to the people involved, but things like basic subscriber information is essentially up to the internet service provider whether they tell their customers or not. That is, unless law enforcement gets a special provision saying that disclosure is not allowed. And it's typical things like law enforcement worrying about destruction of evidence or flight from prosecution, where law enforcement would include an ECPA provision saying that the parties being investigated would not be notified. Now, the ECPA is not a law with criminal penalties. It's basically set up as a guideline for how law enforcement can obtain information from Internet service providers. So it has no criminal penalties. It does allow for, but doesn't establish, but it allows for civil penalties. So, for instance, law enforcement that have violated the ECPA might face a lawsuit from the people involved due to the violation of their privacy and violation of the ECPA. The ECPA is a very complicated statute, but it's becoming one of the most important ones in law enforcement involving any kind of digital evidence, because as more and more digital evidence becomes internet or cloud-based, more and more it will be the case that evidence is hosted by some internet service provider, and law enforcement is becoming more and more reliant on getting this evidence from the internet service provider, and that entire interaction is governed by the ECPA.